Hello, lovely friends and students and all lovers of the law. SLP Ghana is proud to welcome you to the 2024 exciting year of studying the law. We are grateful for all the amazing reviews and comments that we've received from our students in University of Ghana, Legon, KNUST, GIMPA, Central, and all of you. Keep sharing, keep commenting, and keep on liking our videos. This year, we're going to give you something very special. On the 9th of January, visit our website. We're going to give you much of the details of what is involved in our 2024 Ghana School of Law entrance exam prep class. Also, there's going to be exciting videos that will be released from the 9th. It will be available on all our social media handles, YouTube, Instagram, and the rest. I'm proud and excited to have you guys back in 2024. Stay tuned as we give you much of our beautiful and educative videos on studying the law. Alright, guys, you're welcome again to our continued videos on the law of contract. Now, you would realize that over the period we've been discussing the elements of a contract. We've said that the contract is like you are trying to build a house. There's always has got to be with a kind of a foundation. So the foundation should have some particular elements or stuff in there. Okay, when you have those elements and they are there, we know that you are now set to make progress. A contract is just like that. There should be some other parts or things that should all be together. And the coexistence of those items will allow the contract to be valid. These are the things that we mentioned as the elements of a contract. So we've already mentioned, for example, an offer. There has to be an acceptance. There has to be an intention to create legal relations. There has to be a capacity to contract. Then there should also be what we call the consideration. In this video, we are going to focus on the consideration. It's going to be at least the first part of this, or about 2 divisions on the subject of consideration. We will learn about the definition of consideration and how that manifests itself in the whole scheme of affairs when it comes to contract law. All right, now, so let's move on. What is consideration? What is consideration? Now, I'll take you from a very common, the loose meaning of consideration. We hear people say that, look, I've considered it. I'll consider it. Okay. When someone says you consider something, what does it mean? It means he's going to think about it. When he thinks about it and it fits into certain schemes, then he decides to go ahead of it. You understand that? Now, basically, in a bargain or in an arrangement or an agreement, let's say someone sees an item in a shop, okay, or he sees a vehicle that he wants. He goes and he tells the person that, okay, Charlie, this is your car. I want this car. Oh, will you sell it to me? Then he says, oh, this car is like $50,000. Oh, really? Okay, I'll buy it. I'll buy it, okay? I'll buy it. Then he goes. Guys, what do you think? Do you think that he has any reason to reserve the car for him? If it were you, would you reserve the car for him just by the fact that he said, oh, I'll buy it? So that is all. No. I mean, he needs to show something. Is that not the case? He needs to demonstrate some kind of commitment. He needs to show some kind of seriousness. He needs to show some kind of desire, some eagerness that he won't really desires a thing. That act that he will perform or anything that he does, that can give an indication to the other person that he is serious about it. It's a means of helping the person to think about that act that he has performed and says, oh, okay, because this person has done A, B, C, D, I think I'll reserve the car for him. So see, in 2 situations, if he now says, oh, I want it, then he leaves without saying anything. By the time he comes back, I'm sure he will sell it to another person. But for example, oh, Charlie, I want it. 50,000. Okay, you see, let me just give you a check of 10,000. He writes it. He dashes out the check of 10,000 to him. You keep this, okay? Do you think that the other person or the owner of the car will have any business in trying to sell the car to another person? Do you think so? No. Why? Because this person has given something. He has showed some commitment. Aha. Let's go to another scenario. A man meets up with a girl and a woman, and he promises the woman that he wants to marry the woman. All right. So I'll marry you, Amma. Okay, I'm here. So you go come. But let's say the man goes to another step. He tells his father that, Dad, I've seen this lady I'm crazy about. I want to make her my wife. You know, I want you to go and see her parents and ask for a hand in marriage. So the family organizers put together a offer and some other principal members of the family together. Then they go to see Ama's parents and do what they call a knock-in. Now, question, do you see that that is a statement of intent? That is a statement that shows that they are serious. So guys, the point is that anytime there is an agreement between two persons, it is a natural statement of fact that before the two parties can begin to take themselves seriously, there has to be a third element. And that third element to be a certain show of commitment, a certain show of seriousness. In law, we call that act that demonstrates seriousness. We call that act that demonstrates commitment consideration. It is consideration because of that particular action, the person will think about it and he will know that, no, this person is serious. That is why he will consider it. It is called consideration. I hope you get it. So in the car example that I gave you, if I went there and I gave him 1,000 cedis check, okay, the one who wanted a car wrote 10,000 cedis check and put it bam on the table. If he is thinking about someone else who is exercising interest, he will consider what this person did, and therefore he will not what? Look at the other fellow. That is consideration. You get it? All right. So I guess you are beginning to get a bit of a sense of what we mean by consideration. Any act or item or situation that can be constituted or to mean a show of desire, a show of seriousness, a show of commitment. In law, we call it consideration. But now you see, as in law, we always look at the authorities and we refer to one very powerful common law case. The case was Dunlop Pneumatic Tires Company versus Selfridge Company Limited. It was in that case that Lord Dunnington gave us a definition, and that definition is so powerful, so far-reaching that it gives us a lot of clarity on what we mean by consideration under law. Let's see what the court said in Dunlop Pneumatic Tires Company Limited versus Selfridge by court. Speaking of consideration, an act or forbearance of one party or a promise thereof is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. Did you notice what the court said in that Dunlop case? He says that an act, a forbearance of one party, and a promise thereof is the price for which the promise of another is bought. So now, three things are apparent in that definition, and that tells us what consideration is. One is an act. Two, a forbearance. Three, a promise thereof. Now, notice that the definition mentions that it is the price for which the promise of another person is bought. Now, guys, let me give you an analogy. When you go and buy an item in a shop, or someone goes to a shop to purchase something, so it's a dress. So you go, you see this dress, you love this dress so much. They ask you, this dress is 1,000 Ghana cedis. That's the price. Now, if you pay the price, what is the meaning? Let's get it right. If you pay the price, what is the meaning? What it means is that you are now buying the item. Now, in paying the price, buying the item, the person who is selling the item will therefore have no right to give that item to anybody else. Is that not the case? Because you have paid the price. So now, when you take this particular analogy into the definition, we are saying that the price that someone pays for another person's promise, he buys that promise. So if you make a promise to somebody, okay, or B makes a promise to A, and A buys the promise, he buys it in the sense that he will have to do something, and that act will constitute a price in the sense that B therefore will have no right to make that promise to another person. So that act that he does, or that price, is what we call consideration. Hope you're fine. The price for which a promise is bought. So when someone buys somebody's promise, he pays it in such a manner that you cannot allow that promise to be made to another person, any else. If there is any honor of that promise, the honor of the promise has to be done in behalf of the person who paid the price. So the question is that, how then do we pay a price for a promise? Three ways, consideration. One is an act, a positive act. Example I gave you, when someone goes to buy a car, what happens? He sees the car, he likes the car, he makes a deposit, right? So by making a deposit, what has he done? What has he done? He is purchasing the promise to give him the car. So once he makes a deposit, you cannot promise another person to give him the same car for which another has paid a deposit. You get it? So in that sense, he has bought that promise, and therefore it is consideration, a positive act. The case that we want to refer to is Edward Santin versus Dr. Edward Aqua. Now, if you've not seen the video on Ghana legal systems where we discuss the rule of equity, we spoke much about that case in the rules of equity when we discussed this case of Edward Santin versus Dr. Edward Aqua. It was a case of two people. This man met Dr. Aqua, and Dr. Aqua had said that he wanted to give him a land at Oyarifa, 99. The price was 42 million old Ghana cedis by then. So what Dr. Edward Santin, Neo Oshika, did was that he gave him 4 million cedis, okay, and said that he wants it. So take 4 million as part payment and prepare the documents, and I'll give you the balance of 38,000. All right. So eventually something happened, and they were trying to pull the first one in, so the court had to step in. But though the court did not make a decision on that, the point is this: the matter was settled in favor of Edward Santin because he paid a price for the promise to give him the land. What was that price? By giving him 4 million. Okay, so we are saying that an act could constitute consideration. All right? Yes. So when we say consideration, when there is an offer and an acceptance, when someone has represented a fact and made an offer to somebody and the person accepts it, the person who has accepted the offer, okay, may then do another act to show that he is serious, he is committed. He will do an act that, well, if you consider that act, you cannot do anything. That is consideration. And that's the example that we want to give for that. So that is fine. Now, it also mentions again in the definition by the learned judge in the Dunlop case that consideration will also be forbearance. Forbearance. What is forbearance? Hello. Do you plan to sit for the 2024 Ghana School of Law entrance exam? Have you written it once, twice, or thrice? Let this be your last. Join SLP Ghana on our 6-month intensive weekly preparatory class for the 2024 Ghana School of Law. The venue will be the Accra Technical University campus from the month of March to the month of August on Sundays at 3 to 6 p.m. each week. For further information, you can visit or you can WhatsApp on 0540-550-541. Join us as we embark on helping you to begin your journey to the bar. All right. You see, forbearance by the authorities and the definitions of both legal dictionaries is where someone has restrained himself from doing an act that he had the right to do. It is forbearance. Okay? The law is that it can also constitute consideration. It can also constitute a means for which the person can be said to have paid a price for a promise. Let me give you an example. Let's say that Joe was working with his boss, Ato. All right? So in the course of the business, Ato, the boss, realized that some particular funds in the business that had been put in the care of Joe was missing. He observed that for a very long time. Ato saw that. So eventually, this whole investigation, one day he caught Joe red-handed and saw that it was Joe who was taking money from his coffers. So he decided to report the matter to the police. He called Joe. Joe, I've done an investigation. This is what I've seen. He confronted him with the evidence. Then Joe was saying that, boss, I beg you. So I'll give it to the police. You know what then? Joe immediately took the phone and called his wife, Mariama, and told Mariama that, Mariama, this is what has happened. Then Mariama was scared. All right, so Mariama now found a way of meeting Ato and went on his knees and told that, boss, I beg you, don't take my husband to the police station. Otherwise, this thing, I will be in trouble. If he goes to jail, I don't know what he's going to do. I'll pay the money. I'll pay the money. This is what Mariama told Joe, told Ato. So Ato said, are you sure? He said, I beg you, please, don't make this a police matter. I beg you. All right, so Ato accepted. Now the question is that, is there now a contract between Mariama and Ato? Is there now a contract between Mariama and Ato? So Mariama offered to pay the money to Ato, and Ato also accepted, right? But the question is that, was there consideration now? There's consideration. That consideration is forbearance. The forbearance is that Joe has a right to report, Ato has the right to report Joe to the police. It is a right that he has, a legal right. He has a right to do that. The only reason why he has not exercised that right was because Mariama has made an offer to him that he is going to what? Pay the money that his husband has what? Stolen. Guys, you understand that? And Ato has accepted it. So the fact that he restrains himself from exercising that legal right, that thing that he had the right to do, it constitutes consideration. So tomorrow, Mariama cannot now turn around and say that, oh, like what they will say in a car, I said it, but I can't do it. You can't say that. That is consideration. That itself is forbearance. So sometimes in practical life, people may do things. They may not necessarily use money, but by conduct, they'll forbear. They'll forbear. It could be an exercise of legal action. It could be constitute a forbearance. Maybe someone has an issue. Maybe he's owing somebody. Then they allow lawyers to write to you and tell you that, look, if you don't pay this money, we are going to commence legal action against you. Then you go and tell them that, oh, please, you don't take me to court. I will pay. Once you say that, and it prevents the people from exercising court action, a contract is there. Why? Because there has been a consideration. There is a consideration in the sense that the person has been restrained from doing the lawful act. You understand that? But remember, that restraint is something that the person should have restrained himself from doing something that is lawful. So, in a converse situation, if, for example, somebody is owing another person, A is owing B, and B catches A, and is giving him slaps, wah, wah, wah. Now, D comes and tells him, oh, B, please, don't beat A. Don't beat him. I'll pay the money. You pay the money. You're like, I'll see what I'll do to you. Now, the question, is there a contract between B and D? I'm sure you may hasten to say yes. But you see, he restrained him from doing an act. But was that act lawful? You beating somebody, is it lawful? So if you restrain from assaulting somebody, it cannot constitute forbearance in law because that act itself is unlawful. Guys, hope you're okay. So note that when we talk about forbearance, it is a person restraining from doing something that he had a right to do, and that thing itself should have also been legal. That restraint to do should have also been legal. If it is not legal, you can't say that the fact that you refused to do that was forbearance. So forbearance will not admit of issues of concealing crime or those kind of things. Hope you're okay. Okay, so in one of the famous cases that you might have heard, Dele and Dele versus Uzwe Free, it was a couple who had a business with one other man. Okay, then along the line, the man was indebted to them. Uzwe Free was indebted to the couple. Now, as a result of the indebtedness, along the line, they decided to take him to court. Then also Free wrote to them and told them that, oh, he's begging. They shouldn't take him to court. Then they stopped. Okay. Then eventually he was saying something else. Then they decided to commence another action. Now, the court held that there was a contract. There was a contract because they had forbade, restrained themselves from exercising a right which they were legally entitled to do. The law is that in itself can also be considered as consideration. Are you okay? So for the students, if you have a question on the law, on contracts, and you are trying to see whether consideration was there, these are the things that you have to be looking at. Look at it. Is there a positive act? Or is there a situation where one of the parties has restrained from performing a right, something that he had a right to do, in reliance of another promise? If it was there, it could constitute forbearance, and therefore it could amount to what? Good consideration. Hope you're okay. All right. So we'll take a case that's what Cockburn, Chief Justice, had delivered, and it was Kalisher versus Brokenshire. Let's see what the court said on that with respect to the restraint of a legal right by court. Cockburn, CJ, said, the authorities clearly establish that if an agreement is made to compromise a disputed claim, forbearance to sue in respect of that claim is good consideration, and whether proceedings to enforce the disputed claim have or have not been instituted makes no difference. Let's take the third situation. All right. So we are saying that the definition that was given in the Dunlop case, a consideration could also be a promise. All right. So someone could make an offer to another person. The person accepts the offer. Then he pays the price of the offer by making a further promise. That itself is consideration. I hope you understand that. Yes. So you might have heard of undertakings. Undertakings can be consideration. Okay. So someone has an issue with somebody. Look, you are owing him. He says, oh, okay, I'm going to pay you You agree. So he makes an offer to pay and you also accept. So in making an offer to pay and accept, what happens? The person will make further promise. And that promise could come in the form of an undertaking. He will write a document. That document is not money. It is just a promise that he has put on paper. Hope you understand that. So, but that in itself is consideration, because it is a way of trying to make sure that that bargain is tight. That is why sometimes if those students, when you go to school and the university, you are not able to pay your fees, what do they tell you? Come and write an undertaking. Said that, it creates a binding contract between the two of you, because then a promise has been done. And in consideration of that promise, that undertaking, they will allow you to go and write your exam. That creates a binding contract between you and the university. You understand that? Also, sometimes these matters can come up in situations where we have what we call the breach of promise to marry. You know, under the laws of Ghana, if you're a man and you promise a woman that you love her, and the woman says, oh, I've accepted your proposal, and she promises that because of you, I will not go after anybody. That promise that she has given is also consideration. Okay, so if later you use some fair and foul means to desert her and chase after another woman, she can take you to court for breach of promise to marry. It is also consideration. She has not given you money. She has not given you anything else. But you see, there was a promise to marry. She accepted. Then she also made a promise that because of this proposal she has accepted, she will not go after anybody. That itself is consideration. And the law recognizes that. There was an article that was written by the learned Professor Nana Jane, Justice Professor now, Henrietta Mensah-Bonsu, 1995. It's on that particular subject. I mean, the breach of promises to marry, whether they are actions that are maintainable by the court, whether if a woman says that a man promised to marry her and she agreed, and out of reliance on that, the man deceived her or didn't marry her, the person could also go ahead and sue in court. The courts of Ghana has held that those actions are maintainable. I think in one other matter by Justice Doche, that was held by the court that accepted. So, guys, that's the point. The promise thereof constitutes a consideration. Hope you're okay. All right. So, in summary, we have in this video discussed what we mean by consideration, the definition of consideration. We are seeing that a consideration could be an act, a forbearance, or a promise for which the price of another promise is bought. And like we illustrated, if someone purchases an item, he is entitled to exclusive use of it. If someone buys something, he's entitled to exclusive use. So someone pays for a promise. It means that that promise has to be honored only in his favor. And that payment could be done by an act that he has done, or it could be by forbearance. He has restrained himself from doing a rightful action, or it could also be because there has been further promises to it. Anytime you have any of these three situations panning out, a consideration is there. The person has evinced an intention, a desire, seriousness, that he wants that particular agreement to be binding on those two parties. And the law considers that the element of the contract of consideration has been properly satisfied. Hope you're okay. All right, so this is just the first in our two-part series of consideration. In the next video that we'll be watching on consideration part 2, we'll discuss some of the rules under consideration. The Contracts Act 1960, Act 25, has made statutory inroads into what we know about consideration. We'll discuss some of them and some other reasons. Stay tuned. Consideration part 2.